Professor?
Yes, Your Honor.
Yes, there is always an existential threat to every generation, but you think that it might be irresponsible for us not to allow Congress to try to find the balance to address both the existential threat as well as protection to the rights that are enshrined in the Constitution.
Yes, Your Honor.
So in other words, we cannot assume that just because there is a law, that there is already a challenge to the Bill of Rights. Is that not correct?
Yes, Your Honor.
And it is also right for us as a body that has been constituted only as the judiciary to assume that the members of the House, the Senate, and even the President is very aware of all the provisions in the Constitution. Is that not correct?
Yes, Your Honor.
And therefore that they may have already seen, in fact, predicted that there will be at least one petition, perhaps they did not predict that it will be 37 and more, that will be filed in the Supreme Court whenever they try to address the perils of terrorism. Is that not correct?
Yes, Your Honor.
Yes.
We might.
And therefore, well, you quoted Justice Jackson. Is that a Filipino justice?
No, Your Honor, but
Yes.
his ponensya was already...
Yes, but why should we
incorporated
listen
in
to
Philippine
Justice
Union.
Jackson? It's the Philippine flag that flies over the Supreme Court. Because I noticed that you are fond of citing Jackson, Baker versus Carr, U.S. versus Stevenson. These are not jurisprudence here. Is that not correct?
Your Honor, yes.
You might
are
have
correct.
as well cited South African jurisprudence or Indian jurisprudence. But as far as we are concerned, as I will show you later, we have had our own interpretation of actual case and the more recent one. Is that not correct?
Yes, Your Honor.
Yes, okay.
Yes.
So, in other words, the court has maintained a policy of deference simply because of the nature of the court itself. Is that not correct?
Yes, Your Honor.
Yes. And, well, for example, there is this case of the ITA that was mentioned by, I think, Attorney Latif. But my question is related to your share of the oral arguments. Isn't that the actual case?
The ITAS, Your Honor?
Yes, the ITAS were charged with provisions of terrorism. Provisions that are found under Republica 111469, correct?
Yes, Your Honor.
Yes. Isn't that the actual case?
Yes, Your Honor.
Isn't that the perfect case that will delimit the actual challenge to clear provisions in the Constitution based upon clear facts? Because as far as we are concerned, for example, you mentioned that there was this post saying that some members of the UP community were communists that were captured or killed. Is that not correct?
Yes, Your Honor.
Yes, and in fact, one of the lawyers there, I know him, Rafael Aquino, came out and said, I am neither captured nor killed. I
Yes,
was
Your Honor.
never captured nor killed because here I am, right?
Yes, Your Honor.
Yes, and what happened to that?
I believe, Your Honor,
It was withdrawn, correct?
Counsel here.
Yes, it was withdrawn, correct?
Yes,
It was
Your Honor.
withdrawn, yes. And the Secretary of National Defense apologized. Is that not correct?
Yes, Your Honor.
In fact, he fired, or I think he demoted or removed the J2.
Yes, Your Honor.
J2 is, I think, part of the Chief of Staff of the Armed Forces, and that is number 2.
Yes, Your
If I'm not mistaken, no, I think it's 2. Number 3, because 1 is, I think, operations, if I'm not mistaken. 2 is intelligence. And in fact, even a deputy of the spokesperson also took a leave because of that snafu. Is that not correct?
Yes, Your Honor.
And it is maybe not for this court to base its ruling on that set of facts because that is not the case. It evolved and the government itself corrected its error. Is that not correct?
Yes, Your Honor.
Yes. And with respect to frozen assets, there is the case of rural missionaries. Is that not correct?
Yes, Your Honor.
As a matter of fact, I heard one of the counsels today say, I cannot state anything about that case because she is not the counsel to the case. Is that not correct?
Yes, Your Honor.
And we are to rule on a constitutionality of the provision of freezing of assets on the basis of facts, which are in another case and which can be pending with the Court of Appeals. Is that not correct?
I believe the RMPs are
You mentioned
consolidated with this
you
case.
mentioned rural missionaries, you mentioned Facebook posts, you mentioned red tagging. All of them can ripen to actual cases that can be filed either with this court, if they so wish, based on Gios versus Samar, however, with a warning, or with the lower courts. Is that not correct?
Yes, Your Honor.
Yes. So you are now asking this court to rule upon a law that is live, that has already, according to you, have had many consequences. Is that not correct?
Yes, Your Honor.
Yes. Now, so therefore, the concept, I think many of us have difficulty, although we understand the positions of many of the petitioners, we understand the fears. Personally, I truly understand the kinds of fears that you're undergoing, having undergone those fears myself when I was a public interest lawyer. I understand that. But with the hat now of a justice of this court and with this judiciary, I think it is correct for us to assume that we should be careful not to become a political department. Is that not correct?
Of course, Your Honor.
Not to substitute our political wisdom to the political wisdom of, let us say, those that have crafted this law and those that have advised the president, including the National Security Advisor, who I believe is in the room. Is he here? The National Security Advisor. We have allowed him to be present. Give advice to the president and perhaps even to some key leaders of Congress. Is that not correct?
Yes, Your Honor.
Yes. So only in an actual case where it can be clear, there can be a clear and convincing demonstration that there is repugnancy with a specific text in the Constitution, will there be an act by this court. Is that not correct?
Not necessarily, Your Honor. I beg to disagree. Of course, we do allow facial
So
challenges
Francisco
to this
versus
jurisdiction.
House of Representatives, when was this case promulgated?
Your Honor.
Francisco versus House of Representatives, when was this promulgated?
Your Honor, this I believe it's
2003.
the video.
2003,
Yes, Your Honor.
right? Southern Hemisphere, when was this promulgated?
After the
2010.
1987.
The Sini, when was this promulgated?
As well, Your Honor.
2014. Imbong, when was this promulgated?
I failed to
2014.
recall the actual.
Did you ever mention Gio Samar? When was this promulgated?
I believe 2 years ago, Your Honor.
2018, right? And who was the ponente?
The amicus.
Amicus. And this court, of course, when I was absent, I could have voted also for him to become amicus. But he's now amicus. Isn't that a signal? Perhaps it is, correct?
Yes,
So
sir.
now, Gios was 2018, right?
Yes,
And
sir.
none of you have mentioned the slew of cases that followed Gios. And I will show you there in the PowerPoint that there were cases like National Federation of Hog Racers. There was the case of Provincial Bus Operators Association. There. Falsis versus Civil Registrar General, where the Solicitor General won in that case on same-sex marriage. By the way, do you know the ponente of Falsis?
It was you, Your Honor.
Yes. And then Provincial Board Bus Operators. All of them, by the way, are unanimous decisions of this court. Let's look at the last case, Parconsong versus Lilia Parcon, where the court said, in terms of the extraordinary jurisdiction of the court, can we flash that quote? This is again, Article 8, Section 1 of the Constitution, which specifies that courts may act upon any grave of abuse of discretion by any governmental branch, does not license this court to issue advisory opinions. Apart from an actual case or controversy, this court must be satisfied that the reliefs prayed for require the resolution of a constitutional issue. But there is an exception, of course, in Parconsong. Are you aware of the exceptions? Again, this
Yes,
is
sir.
part of a unanimous decision of this court, correct?
Yes, sir.
Yes. So, therefore, it is clear that it again reiterated the case of Southern Hemisphere. Is that not correct?
Yes, Your Honor.
Yes, okay. In Southern Hemisphere, however, it is not that freedom of expression is alleged as having been violated. Not only that, there is an additional requirement, correct?
Yes, Your Honor.
That there must be a clear showing of overbreadth. right?
Yes, Your Honor.
And there's a difference between overbreadth and void for vagueness. Is that not correct?
Yes, Your Honor.
Yes. Can you make a differentiation?
Void for vagueness, Your Honor, offends the due process clause in the sense that two reasons. One, it deprives fair notice to the individual on what the criminal behavior is.
And as clearly stated in a ponencia, if I'm not mistaken, by Justice Ardelesa, void for vagueness, because it applies only for the due process clause, requires as applied. There must be actual facts, correct? So what we are talking about when we invoke the exception in Southern Hemisphere is overbreadth of a provision that will run afoul the freedom of expression clause. Is that not correct?
Yes, Your Honor.
But that was qualified. So Southern Hemisphere was way back in 2010, correct?
Yes, Your Honor.
And there is now this, again, unanimous decision of this court in Spark versus Quezon City, which you mentioned, right?
Yes, Your Honor.
And I think the ponente herself quoted a very clear statement in that provision. It is not that it appears void to the petitioner. It is not that it appears void to the petitioner, but that there must be a clear and convincing showing that there cannot be any other interpretation except that it will infringe a certain right. Is that not correct?
Well, Your Honor, I would, with due respect to my former professor in constitutional law, disagree that facial challenges only follow that line. There are also facial challenges that have more recently been recognized.
Name one.
Your Honor, in I think because the formulation you are referring to is Salerno.
Lloyd and Nicolas.
Yes, Your Honor.
There were facts.
Yes, Your Honor.
They were excluded
2019. Yes,
from
Your
the campaign, correct?
Yes, Your Honor.
So there were facts,
Yes, Your Honor.
right? So now, do you have facts?
Yes, Your Honor.
What facts have been established by
The
evidence?
operative fact in a facial challenge, Your Honor, is the passage of the offending law against
I'm sorry,
the text of the
again?
Constitution, Your Honor.
Again, well, just today, in the case of Diraugo versus Martires, this court again reiterated that line, dismissing a petition outright on the challenge to Memorandum Order Number 1, very clearly stating that it cannot just be the law, but there has to be facts that arise in order that we act on our power of judicial review. Just the passage of a law, I think this was the generous wording in Francisco versus House of Representatives, but then again came Southern Hemisphere, and then after that, Gio Samar, then after that, Parconsong, then after that, all of those cases, including the case of Spark. You seem
Yes,
to
Your
have
Honor.
missed all that jurisprudence.
Well, Your Honor, of course, I would agree with you.
Of course,
Your
it's
Honor.
understandable because one of your petitioners is really the ponente
Yes,
of
Your Honor.
Southern Hemisphere, correct?
Yes, Your Honor.
But even her ponencia was very, very clear.
Yes, Your Honor.
And it was clarified further by other cases which evolved based on the history of this country and based on the jurisprudence of this court. Is that not right?
Yes, Your Honor.
Yes,
And
so-
if I may,
What are your facts?
yes, Your Honor. If
Do
I
you
may,
have facts?
Yes, Your Honor.
What are the facts?
Your Honor, that Congress has in fact passed a law that violates the
No, that's not a fact.
Your Honor,
That's the passage of
unfortunately,
a law.
if we follow your line of thinking, then we would be
No, it's not
erasing
my
the
line.
distinction
It is not my
between
line.
as applied challenges.
Excuse me, counsel. It is not my line.
I'm sorry.
I have shown you the genealogy of jurisprudence.
Yes, Your Honor.
Baka nga lumabas sa bar yan kung ano, di ba? It's not a tip. But in any
Yes, Your
case,
Honor.
the point there is that line of jurisprudence.
Yes, Your Honor.
Yes. So how do you contend with that? Where the court clearly said it is not merely the passage of a law that entitles a person that will come up here to annul that law, because otherwise it's an advisory opinion. We act as a third chamber of the legislature over and above the approval power of the president when we act upon a law without the facts. Precisely, the judiciary was created in order to be able to look at evidence that generates facts which may have been overlooked by the legislature and the president when they passed the law, or to help clarify the text of the law. In the absence of those facts, It is up to the president when implementing the law to pass implementing rules to guide the execution of a particular law. But it seems to me that even implementing rules of the president, here the ATC, because it clarifies concepts such as designation and delisting, because it clarifies concepts like inciting and advocacy, that you want that annulled even, disregarded. And you want us to focus on the law, and instead of giving liberality to the political departments to do what is right by the Constitution, you want us to exercise our power to jump the gun and simply say the law is unconstitutional.
Well, Your Honor, if I may answer the line of questioning of the Honorable Esteemed Justice.
But there is no question yet.
Oh, sorry.
Yes. Isn't that what you want to do?
Your Honor, we are invoking expanded judicial review. In 1987, when Justice Cecilia Munoz Palma delivered her closing remarks,
again, with
the
due
last
respect
session
to, with
of
due
the
respect to
Constitutional
Cecilia Munoz Palma, when she made that speech for the Constitutional Convention, that was 1987, correct?
Yes, Your Honor.
And how many years have passed since 1987?
34 years.
And there is a constitution that has to address everything that happens in our historical timeline from 1987 to 2021. Is that not correct?
Yes, Your Honor.
And now in 2021, it is this court that sits.
Yes, Your Honor.
So you want us to forget all the jurisprudence that has been evolved from 1987 to 2021 and simply disregard all of this advice to petitioners. Come to court only if you have the facts. If it is irrefutable, come to court only if you have a freedom of expression case when you want a facial challenge, but show to us clearly and convincingly that the political departments cannot interpret it in any other way except to chill and to violate the right of freedom of expression. Do we have that now?
Yes, you do, Your Honor. Yes, we do.
In spite of the implementing rules?
Yes, Your Honor.
For
Because,
instance?
for example, Your Honor, let's go into the subject of chilling of speech. The sword of Damocles, the damage under constitutional law is not because it falls.